Okay, let's get into the presentation. And today's topic is about the appointment of arbitrators. So we know that appointment of arbitrator happens with the section 11 of the Arbitration and Conciliation Act. So wherein here, so there are cases where, depending on the cases, the judgment, it differs how the appointment has to be done. So we talked about a benchmark case, which is called the Perkins Eastman case. So that was considered as a benchmark judgment from 2019. That's what you're talking about. And currently there is a different judgment. So we have to refer to both these things and to understand what is the exact difference between the judgments in terms of appointing an arbitrator. Can you move on to the next slide, Ram? All right. So before we get into this, right? So I thought like it's better to know the related sections which is going to be discussed within these particular cases. So out of that, section 11, it talks about the appointment of arbitrators, and section 11, subsection 6, talks about where under an appointment procedure agreed upon by the parties, and then section 11, 12A. So it talks about where the matters referred to in subsection 4, 5, 6, 7, 8, and subsection 10 arise in an international commercial arbitration, the reference to the Supreme Court, or as the case may be, the High Court, in those subsections shall be construed as a reference to the Supreme Court. So these are the section 11 which we will be discussing, and then section 12, it talks about grounds for challenge, how you can challenge an appointed arbitrator. So that is the grounds for challenge. And then 12.5, which is important, where it comes as part of this case. So notwithstanding any prior agreement to the contrary. So any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator, provided that parties may, subsequent to dispute having arise between them, waive the applicability of the subsection by an express agreement in writing. So when somebody is like appointed as an arbitrator, there are some things which has to be followed. If not, then both parties has to agree in order to come to the conclusion. And section 29A talks about the time limit for arbitral award. So these are the sections we will be discussing today. Ram, can you move on to the next slide? All right. So when we talk about the benchmark cases, so far we have been discussing that Perkins Eastman Architect versus HSCC India Limited. So that was given in the year 26th of November 2019 by Supreme Court of India, and then followed by there was another judgment in terms of appointing an arbitrator. That is called Central Organization for Railway Electrification, which is in short called a SCORE, versus ECI, joint venture company. That judgment was given in 17th of December 2019 by the Supreme Court of India. So the latest one that just came out recently in 2020 is like iWord Business Solutions versus Delhi Metro Rail Corporation. That was in 4th of December 2020 in High Court of Delhi. So the reason why I just put them stack them one by one, the order is, so Perkins Eastman was the first one, and then came the core versus ECI judgment. That was slightly different. And right now the iWorld Business Solution has been adhering to the judgment given by the core versus ECI. So these are the 3 cases. So now let's get into the Perkins Eastman case. So there are 3 things we each is going to discuss here. One is the principal relief, what has been asked for, and what classes that comes inside that particular contract, which is the basic point behind all these discussions between those 2 contracted parties. So that's why I thought of bringing that up. And then what is the judgment that was given? So the principal relief which you talk about is let's go through this and then let me get into the case. So the application under section 11.6 read with section 11.12A of Act, and under the scheme prays for the following principal relief. So they are asking for some relief. What is that? Appoint a sole arbitrator in accordance with clause 24 of the contract, which has been done on 22nd May 2017 between the parties. So appointed may adjudicate the disputes and difference between the parties arising from the said contract. So there are 2 companies, which is we talk about here called Perkins Eastman and then HSCC India Limited. So here, HSCC India Limited, who is our respondent, he issued a request for proposal on 15th of July 2016 for appointing some design consultants for the project that they're going to work on. So at that point, the consortium of Perkins Eastman Architect, and which is like situated in New York, and then 85 Consultants Private Limited, who is based in India. These are the applicants. They submitted a bid on 2016 September. So the bid was accepted. Subsequently, a contract exists between HSCC and then Perkins Eastman. So in this, when we talk about this, there is a class as far as whenever they did contract, there is a dispute resolution class. So here, the dispute resolution class 24, that it is like detailed. So I just given a brief here. Probably we can get into that later. So here the design, what is the class that talks here is the design consultant, if he considers any work that has been given, it's like demanded of him to be outside the requirements of the contract. If he thinks so that it is beyond the contract, something is expected out of him, then he shall promptly within 15 days request CGM HSCC in writing for written instruction or decision. So he can raise that why there is a demand for some additional work which is outside of the requirements, and he can write to that HSCC, who is our respondent, and asking for a written instruction that if you want to do this, then I should require written instruction. So that is the class 24 dispute resolution, and that further goes on like they have to respond within 30 days from the date, and then they will be like providing a solution. And if the consultant is not happy with the solution, he can again write back. So at that point, the chief general manager comes in, and he has to provide a solution for that, and that has to be accepted by the design consultant. And still, if he is not agreeing to that, then he can call for an arbitration through a sole arbitrator. So that is what the dispute resolution class 24 talks about. So in our case, what happens is, okay, the applicant contended that the CMD would be interested in the outcome of the dispute, and hence an appointment by the court should be made to maintain a prerequisite and impartiality. So okay, so he raised that concern, and then what happened in between was like there was a delay in terms of response. So the respondent HSCC, he was not properly responding, and then finally when the consultant takes that to the top level, like the final outcome, so the respondent was non-cooperative. So he writes a letter to that them saying that he's not happy with the resolution provided. So he writes a letter on 28th of June 2019, but there was no response. And after 30 days, which is the exact time frame, on 30th of July, they respond saying that they have appointed an arbitrator called Major General K.T. Garia as a sole arbitrator. So the respondent delays the response as well as he appoints a sole arbitrator after that. So that is the issue. So this issue was raised, and then there are different cases that was referred to this. Like there was a case called TRF. So whether appointing a sole arbitrator by the party, like the respondent, is it valid? I mean, like valid or not? So that is the concern. So so the case goes on, and then referring to some previous cases as well as all this stuff. Based on the findings, the Supreme Court annulled the effect. Okay, it's saying that the appointment of the arbitrator on late basis, that is on 30th of July 2019, and that too by the chief general manager of the respondent, so which is not valid. And Supreme Court clearly stated that its decision is no way reflected upon the appointed arbitrator's competence. Like the person who is appointed, it is not that he is not competent enough to do the work, but that there was a delay, and that was like favored for the respondent. So the SC ruled that out, and then further used its power under section 11(6) of the Act and appointed Dr. Justice Sikri, who is retired, as a sole arbitrator to go through this case. So if you look into that judgment, so that's the thing which is happening, subject to the mandatory declaration made under the amended section 12 of the Act with respect to independent and impartiality and the ability to devote sufficient time to complete the arbitration within the period. So a new arbitrator has been appointed, sole arbitrator, by the Supreme Court, and arbitrator appointed by the respondent was ruled out. And so that's the case with Perkins Eastman. So Supreme Court ruled out the existing arbitrator, and then it appointed a new arbitrator in order to continue this case. So that's the outcome of this case. And let's move on to the next case. That is the Core versus ECI case. So in this case, there are two things just which happen. Right, let me get to that. Okay, so there was a contract which was made between the CORE, which is the Central Organization for Railway Electrification, and the ECI. ECI is a joint venture company. So ECI took up the job, but it failed to complete the work within the contractual period. So that was the problem with ECI. So what happened was, after that, the core, the railway electrification, they terminated the contract between the parties. Since the respondent did not complete the given work in the contractual given time period, the appellant cancelled the termination. I mean, terminated the contract. So that is what happened. So, and the respondent is not happy that the contract has been terminated. So he decided to file a petition before the High Court challenging the termination. So that happened here, the first thing. So if you look into this, the first thing here, the respondent prayed for appointment of a sole arbitrator in terms of clause 1.2.54b of the tender agreement, conditions of the contract. So he was looking for a separate arbitrator challenging the termination. So the High Court then directed ECI to avail the alternative remedy by invoking an arbitration clause. So High Court said, we are not giving any judgment, so you better go ahead and then invoke a arbitration clause and then try to get an arbitrator appointed. So accordingly, then the respondent, that is the ECI, invoked the arbitration agreement as per the general conditions of the contract and requested CORE for the appointment of a tribunal. So this is going on, and the railways, the CORE, sent a list. So once this happened, they understood that, and then they sent a list of panel members, serving in the railway electrification officer grade. So they are serving currently. So a list of people has been, panel members has been sent out, and they asked the respondent to select 2 to act as an arbitrator. I mean, in between the 4. And then once it is done, the railways, the appellant sent another list of 4 people who are retired railway officers. So the first list talks about the existing members who are serving in the railway electrification of some junior grade, and the second list consists of people 4 people who are retired officers. So there's a second list. So the respondent, after receiving both the lists, he did not reply to the letters, and then he just went ahead to file another application under section 11 of the Act. So that is the petition 2 he talks about. The petition 1 was challenging, and then it was referred back. So he filed another one before the High Court seeking for appointment of an arbitrator. So then what happens in the proceeding before the High Court? ECI submitted that since no neutral arbitrator to be appointed as per the the guidelines, it had no other recourse except by filing the petition under section 11(6) of Act. So the respondent thinks the arbitrator is not neutral because the appellant is providing a list, 2 different lists, and ask them to select out of that, because it belongs to the railway electrification, and these people are technically savvy, I mean, in regards to that particular job. So that is the reason why the appellant provides 2 different lists and asks the respondent to select. But the respondent is not happy because he thinks that it is not neutral because it is one-sided. So, and they decided to propose a name of a retired member from the railway board to be appointed as sole arbitrator. So the respondent, they just came out with a name. They proposed as another retired person, probably who they are aware of and probably who is in connection with them, and then they provide the name and then ask them to be the sole arbitrator. So after this, the High Court rejected the argument of railway, which is the appellant, and that they just went ahead and proceeded to appoint a retired judge of a High Court as a sole arbitrator. So High Court completely rejected the railways plan as well as the ECIs, and then they appointed a separate arbitrator who is a retired judge. So here the problem was like appointing a judge as an arbitrator in terms of the government related project, wherein some technicality is required. CORE appellant is not happy. So because the person who is appointed is not technically savvy, and probably he may not be able to provide a proper solution to this. So they decided to proceed and then file a special leave petition to the High Court. I mean, sorry, to the Supreme Court of India against the judgment that was given by the High Court. So they challenged the appointment of the sole arbitrator by the High Court. So that is the main point of the case here. And then the Supreme Court analyzed that, and they have been referring to a few other cases, as well as there is an important clause called 64(3) of B, which provides the appointment of arbitrator, where applicability of section 12 of 5 of the Act has not been waived off. So just going through that, based on the findings, the Supreme Court set aside the orders passed by the High Court in petition number 2. So they decided to cancel the appointment of the sole arbitrator by the High Court, and then they directed the appellant, that is CORE, to send a fresh panel of 4 retired officers. So they requested them to send in terms of class 64(3)B of the contract, and then expressly set out time frames for both the parties to take necessary steps in order to form the tribunal as per the contract. So this is what happened. Like in this case, in the first case, and you want to look at the difference, like in the Perkins Eastman case, the sole arbitrator was appointed by the Supreme Court, and here the sole arbitrator appointed by the High Court has been like removed, and then Supreme Court orders for the appellant to appoint fresh panel of 4 retired officers as per the contract. So that is the big difference here. So when we talk about that, why what is the difference here is, if you look at the conclusion, like in Perkins Eastman case, the persons interested in the outcome of the decision of the dispute must not have power to appoint sole arbitrator. So that's what it talks about. In terms of the Core versus ECI case, in an application under section 11 of the Arbitration Act, can courts deviate from the agreed procedure for appointing arbitrators? Yes, because as per the section, and then as per in the Core versus ECI case, it is a government project. It is not a commercial contract. It is a government project where some technicality is required, and only the person who is inside that, who has the technicality, can be appointed in order to get a proper award, in order to give a proper award. So that was the conclusion by Supreme Court in terms of the Core versus ECI case. So based on this, like I mean, the recent case which we are talking about, the iWorld Business Solutions. It also upheld the decision that was given by the core is ECI case, and then it stood by that. So what it denotes here is that when there is a requirement, when there is some technicality required in terms of government projects, then the court can, like, they can overcome, and then they can ask the company, one of them, one of the contracted parties, to appoint an arbitrator who is like specifically having a technical skills into that particular field. So that's what it talks about. So hope we understand the big difference. Probably I think I was like too much of theoretical thing I was talking about. So that's all, like, the case is all about.